morning, everyone. I'm going to be talking about the habitual offender bill. I think all of us were horrified by the video of a young Ukrainian refugee murdered in the subway in Charlotte by an individual who has a long criminal history. So long, in fact, that it left many of us scratching our heads, wondering why this individual was ever let out of prison. Had that individual been behind bars where he belonged, Irina Zaruska would likely still be alive today. None of us want this to happen in the state of Iowa to someone in Iowa. This is why we have introduced this legislation. The bill creates real and meaningful consequences for habitual offenders, which will make our communities safer. The bill strikes the current language regarding habitual offenders and replaces it with a system that will ensure that for those who demonstrate through their continued lawless actions that they are not willing to be rehabilitated, they will not see the outside of the prison for a long time to come. So here's how the legislation will work. It creates a point system that will determine if an individual meets the newly established requirements for being an habitual offender. It defines habitual offender as an individual convicted of an offense who has previously accumulated 3 or more points from any combination of prior level 1 and level 2 convictions. And level 1 offenses are the most serious: Class A, B, C, and D felonies, and all aggravated misdemeanors that involve sexual abuse, domestic abuse, assault with the intent to inflict a serious injury, or while using or displaying a dangerous weapon, also organized retail theft, and possession of a controlled substance. Now, each of these level 1 offenses would carry a weight of 1 point for each conviction. The bill goes on then to define level 2 offenses as all aggravated misdemeanors that are not classified on the level 1 offense level, serious misdemeanors that involve assault causing bodily injury or mental illness, domestic abuse assault causing bodily injury or mental illness, harassment, unlawful possession of a controlled substance, theft in the 4th degree, and criminal mischief in the 3rd degree. Now, each conviction of a level 2 offense is worth 1/2 of a point. Now, remembering that we define an habitual offender as a person convicted of an offense who has previously accumulated 3 or more points from any combination of prior level 1 and 2 convictions, that individual, upon conviction, will serve a minimum term of 20 years in prison, unless the current level 1 offense that the person was convicted of would carry a higher sentence, at which time the person would be serving that higher sentence under the bill. Now, what this means is that a habitual offender is going to prison for a minimum of 20 years. Our communities will be safer, and the justice deserved by victims of the crime will actually come to fruition. I believe that lives will be saved by this approach to incarcerating individuals who refuse to be rehabilitated. And I have a couple of examples here that happened in Iowa, not in North Carolina, not in another state, but in Iowa. I'm not going to mention the name, but I'll just mention the cases. They're a matter of public record. This individual began his crime spree in 2017, committed multiple meth delivery offenses in 2018, convicted of 2 more counts of delivery of meth, received 2 10-year sentences. 2018, sentenced to prison for 20 years after probation violations. Didn't happen. Wapello County, 2019, placed on parole after serving 9 months between jail credit and prison time. And then here we go, loss of life. 7/31/2020 in Jefferson County, committed meth delivery and involuntary manslaughter. And it goes on. More offenses, 2020, 2021, and then 2021, convicted of delivery of meth again, 10 years. And then in 2025, in June, that's at 4 or so years later, paroled on all offenses. That's the kind of thing that this bill would stop. Here's another example. This individual's crime spree, victimizing Iowans, started in 2008, convicted of theft in the 2nd degree. It goes on from there. 2010, convicted of burglary in the 3rd degree. It goes on, committing theft of all kinds, delivery of methamphetamine, forgery. It goes on and on and on. In 2024, convicted of burglary in the 3rd degree, given 5 years. Possession of a firearm by a felon, 5 years. Assault with intent to inflict serious injury. Again, public safety. People's lives are at risk. And in 2025, Well, he was sentenced in 2024, probation revoked, sentenced to prison, 2025 paroled on all offenses. This is not making our community safer, and this is not justice served. And so that is what this legislation is intended to correct. So, thank you.
Good afternoon. My name is Representative Mike Vondran. I also serve as the Chair of Public Safety, and I'm going to share with you the second pillar of our effort here, and that is with regard to bail reform. I'm going to keep this at a bit of a 30,000-foot level and touch on 6 or 7 key points of this legislation. Firstly, mandatory bond minimums. Magistrates must set bail at an amount endorsed on the warrant unless the amount is lower than uniform bond schedule. 2, written justification. A magistrate can no longer set bail lower than the uniform bond schedule or a percentage of it without providing written justification. We're enhancing responsibility with accountability. Limits on own recognizance, being released on your own recognizance. Defendants are only eligible for this release if they are not charged, if they are charged with a non-violent, non-drug, or simple misdemeanor. Restrictions with regard to bond schedule use. The standard bond schedule cannot be used for individuals that are arrested with these areas of concern: intimidation with a dangerous weapon, felon in possession of a firearm, or any forcible entry. This is in line with our 3 strikes piece of legislation. Pre-trial evaluation verification. Any pre-trial release evaluation prepared by the Department of Corrections must have all information verified by the evaluator before being presented to the magistrate. Lastly, inflation adjustments. Our bail reform is focused on bringing things to present day. The last time this was reviewed was 2017. So our bonding schedule will be reevaluated in consideration for present day needs. Lastly, I would like to just share with this bill also removes the previous restriction with regard, it prevented any required deposit for an appearance bond from exceeding 10% of the total bond amount. That has been removed. Thank you.
Good afternoon. I'm Representative Charley Thomson. I'm Chairman of the Government Oversight Committee. My portion of this is the third leg of the 3-legged stool. It's judicial accountability and transparency. One of the things that first happened to me when I graduated from law school back in the horse and buggy days, 1987, was people started asking me, how should I vote on judicial retention elections? And the most I could muster back then was shrug of shoulders, I don't know. Well, we're kind of at the same state now, which is we have a lot of data that's in the judicial computer databases, but very little of it filters out to the public. This is a bill that will require publication through a website of how judges are performing in a number of different areas. It's taking mostly existing data and collating it on pretrial discretion, sentencing outcomes, appellate review, how often the judge is reversed, and courtroom efficiency. It also provides an ability for the judges to post a 500-word statement of their judicial laws. So the idea here is to preserve judicial autonomy and discretion, but make it available to the public so the public knows, is this judge acting inappropriately or appropriately? I think Iowa probably has far better systems in place, I know they do, than our neighboring states. This is to keep that in place and help us prove and improve judicial transparency all out. Thank you. Are we going to take questions?
Yep, we'll open it up to questions for any of the 3 representatives.
Representative Holt, when Speaker Grassley has talked about this package previously, he said you may have to look at prison capacity. Is that part of it?
Not in this bill. We can look at that if we need to. We don't really think that's something that we need to worry about at this time. Remember, it's going to take a number of years when this takes effect to even increase the prison population. So we don't think that's an issue at this time. But if it becomes an issue, we'll certainly do what we have to do to make sure that public safety is the number one priority.
Representative Holt again, you can accumulate the points in a couple of different ways. If there's somebody who has multiple sort of the misdemeanor level offenses, and they accumulate enough points, it's still a 20-year sentence for them. Can you explain why?
It absolutely is, but none of those are what I would call minor offenses. If you go back and review the level B offenses, and I can grab my iPad real quick to talk about those, but they're not minor offenses. They're serious offenses that endanger public safety and endanger community. So let me go back real quick and find those level 2 offenses that count for 1 point. They're serious things. Let me find it real fast here. You're doing exactly right. Okay, level 2 offenses. Aggravated misdemeanors that are not classified as level 1 offenses. Serious misdemeanors that involve assault causing bodily injury or mental illness. Domestic abuse assault causing bodily injury or mental illness. Harassment, unlawful possession of a controlled substance, theft in the 4th degree, and criminal mischief in the 3rd degree. And again, those things would count for 1/2 point. So you can do the math and figure out how many of those offenses somebody would have to rack up 6 times in some pretty serious offenses. So we don't think any of these are minor offenses. They're threats to public safety and threats to the good order and functioning of our society.
Just to clarify, that the points will be applied to like offenses after the bill would be passed.
Well,
right?
yes. There's no way this would be retroactive. That just, I don't think would be constitutionally plausible. Yeah.
And I had a question to follow up on that about when it would be enacted. Is this something that would be gradually phased in, or how would this work?
I think it would take effect as normal bills do on July 1st. I don't think it's anything we would need to gradually put into place.
And then I guess, how do you respond to advocates who would argue that a better approach would be to focus on investments related to mental health, substance use disorder treatment, things along those lines to help make sure that people don't recommit offenses, lower recidivism rates. Excuse me.
I think we already commit a massive amount of resources from the hardworking taxpayers of Iowa on mental health and all of the issues you just mentioned. I think we already put a lot of resources toward that. I think the data, I think if you talk to any law enforcement officer, they will pretty much tell you that, that a small number of people commit the majority of crime in our communities. There are a number of people that simply aren't willing to be rehabilitated. And I'm reminded of what President Ronald Reagan famously said. He said, we have to get out of the habit of blaming society when somebody just breaks the law and does the wrong thing. So I think we have a lot of things in place already to deal with mental health and all of those things that help in rehabilitation. We'll continue to prioritize that while at the same time recognizing that people that do not want to be rehabilitated are not going to continue to be allowed to get rehabilitated.
There was a subcommittee earlier this month. I can't remember if it was a House or Senate bill, but it was kind of along the same lines. Senate, excuse me. A tough on crime bill, and during the subcommittee there was testimony from Dana Winger from the Iowa Board of Prisons and Parole, who were worried that potentially with the overcrowding in Iowa prisons, I think they're 20% over capacity right now, that things along these natures could potentially create a one in, one out scenario where essentially I think his quote was, choosing from the worst of the worst to free up space. Do you worry about those unintended consequences with this legislation?
Not at all, because I think it depends on how you define prison overcrowding. First of all, that's another discussion. But no, not at all, because we're not going to allow that. We're not going to allow a situation to take place where individuals are being allowed to get back out and endanger public safety. So those are the things that we can evaluate as we go along in terms of funding and those types of things. But that is not going to impede our efforts to make sure that we enhance public safety.
Representative Thompson, can you explain a little bit more about how this public database would work? I mean, will people be able to see where the judges deviated from the recommendations? And what did you mean exactly by courtroom efficiency?
Courtroom efficiency means how quickly cases are moving through the courts. As far as the transparency, yes, it would be based on how their rulings compare to the norms that are set forth.
I mean, some judges are dealing with much more complex cases, like I'm thinking of people on the business court, versus there are some very simple cases. So you're talking about how quickly they rule on motions or turn around decisions?
Yeah, well, I hope we can structure this in a way that takes that into account, because some cases are obviously much more complicated. This is really aimed at getting the criminal side of these rulings out there. The civil side, I think we'll have to deal with later as far as the operations are concerned.
So this database would be related to criminal cases?
That would be the initial portion.
Okay.
So, I think you had mentioned a 500-word statement about judicial philosophy. What's the intention behind that inclusion?
transparency to let the public know how the judge is approaching it.
What would you hope to learn from that?
It's up to the judge what they want the public to be able to discern about their conduct on bench.
So where would this be housed? On the Iowa Judicial Branch website, the legislative website?
We are working on that.
How, I guess, would this differ from information that is already put out by, for example, the State Bar Association when it comes to retention votes for judges?
This would be available for all the public, and it would be, I believe, more robust than what the State Bar is putting out. Also, if you've ever tried to use the court system computers, the information's in there, but digging it out is a whole another matter. So this is going to make it much easier for the public to have access to the court information and how they're judged.
You're talking about the court system, computer system. Is there any talk about funding upgrades to bring that technology up to date, or this is a separate?
We're working on how to get the programming handled. It's always easier said than done, especially with computers. But we know the data is out there. We just have to capture it in a way that is accessible to people. Right now, it's not.
The Chief Justice of the Supreme Court, she had mentioned when she addressed the House of Congress earlier, she was talking about the magistrate system and how there's too many of them. Is that something that you're looking into at all?
That's not really related to this topic, the magistrate reform proposal. This has to do with how the rulings are happening, not who's doing the rulings and where.
She did mention when she was talking that a lot of people are being let go without getting a day in court as a result of how the system is kind of organized. Is that something that you're planning to address at some point?
Again, that's a little different topic from that. You're not going to find anyone more radical in the Iowa House than I am about the issue of indigent defense. I've been very active about that. Been a pain in the neck for a lot of people, to be honest with you. So I support getting that system squared away. I hope that the transparency we're bringing to the system will encourage that along. But I don't want to speak for the whole House, but I think there's a lot of people who support the idea of fully funding indigent defense as we're required to.
About bail.
Yes.
I think the U.S. Constitution only mentions excessive bail.
Cruel and unusual, to be specific.
So, are there U.S. Supreme Court rulings on bail that would in any way affect this proposal?
Not that I'm aware of at this point. I can tell you that this legislation has been created pretty much hand in glove with law enforcement with regard to real need that they see on the street. It's something I've been working on for the last 3 years, and this is my 4th. So it's a situation that definitely needs to be addressed. We have too many victims that are taking a second seat to the individual that's committed the act, and we have too often where we're seeing these sometimes violent offenders being able to walk very quickly. I know in the Quad Cities area specifically, and in Davenport specifically, we've had a number of issues with that. And this is a measure to try and address that as well, and allow our law enforcement folks to spend good time without having to rearrest and continue to move forward.
Similar to the concerns about prison overcrowding for
Yes.
on the sentencing end, is there any, have you spoken with sheriffs or any looked into sort of jail capacity in Iowa County jails?
Yeah.
Folks who aren't used to it?
Let me ask you a question in return. How long do we tolerate criminals on the street, chronic offenders, violent offenders, because we don't have enough space? That's an issue that will be addressed when we have that concern. I've not had anybody raise that question with me thus far. But I can assure you, trust me, I can assure you that this body, this Iowa House, will be supportive of any measure that it takes to make sure that our Iowans are kept safe and secure in their homes and in their communities and their neighborhoods.
One of the main criticisms of the bond system is just, if you have money, you can get out of jail. If you're a lower income person, you can't get out of jail. What do you say to that?
Respectfully, I'm not concerned with somebody's income level. I'm concerned with keeping criminals off streets and keeping Iowans safe.
Okay, thanks everybody.
Are these bills going to be debated
Oh, well, I mean, they're gonna be released here in the next few days, and then they'll go through the normal subcommittee and committee.
They aren't out yet.
No.
One is live. We're hoping the other two are by the end of the day, but you know, some things out of our control.
Thank you.
Thank you all.
Thank you.